think that there's really large implications here. And ultimately, like, this was a charging decision that was made because they wrote privacy preserving software.
So welcome to a video podcast. I don't know what those are called. Organized by us at The Rage and featuring several experts and insightful analysts who are going to talk to us about the still unconcluded criminal trial of Roman Storm, co-creator of Tornado Cash, a privacy service protocol piece of software, distributed network on Ethereum. We just concluded the third week of this trial, which we've been reporting on very closely, and which some of our panelists here have been literally involved in, actually, as the thing has gone on. We've got people here who have shown up in filings regarding the case. So what we're going to do to preview for whoever winds up watching this, we're going to talk through different aspects of the case having to do with the technology, the current prosecution details of that, and talk through some of the complexities, controversies that have been ongoing. The bigger picture around open source software and software liability. One way of summarizing the key element of this case is that it's about whether you are responsible for the use that somebody puts of a tool that you have built in the past, is one way to think about it. And then finally, we're going to go through some of the specifics of tracing blockchain transactions that have been controversial, and that, frankly, the more I think about it, are one of a few options for an appeal if this goes to a guilty verdict. Just sort of logistically, for those who might be listening, we're recording this on Friday, August 1st, after the first day of jury deliberations, and we expect for deliberations to continue on Monday. And, maybe we'll get a verdict on Monday. It does seem like they're really having a deep discussion. So first, what we're going to do is talk about the actual reality of Tornado Cash, what it is, what it does, and to some extent, why it's needed, although maybe, Amanda, at this point, you can also start helping us disentangle the sort of more foundational issues, some of the constitutional elements here, from the actual specifically more narrow elements of the criminal case that's actually happening right now, because there is that two-step appeal process, and certain things have been excluded from the trial. But I want to have Tim Clancy. I should actually introduce everybody first before we go into the full discussion. So we have four guests here with us today. Tim Clancy is an application layer Ethereum developer who's been really involved in drawing attention to Roman's case and to the Tornado Cash situation. Amanda Tuminelli is executive director of the DeFi Education Fund and a former criminal defense attorney, correct? And Molly White, our third guest, is well known as the author of Citation Needed, a blog about cryptocurrency crime, fraud, cryptocurrency as fraud. I guess we should be transparent and say, and also a longtime Wikipedia editor, advocate for free and open source software. And just kind of an expert on the software and information ecosystems. Finally, and I'm sorry I'm rattling through this, but I want to get to the discussion, but we have Taylor Monahan, security at Metamask, and also a long time, this gets a little bit into polishing our own apples, but Taylor and I have both been around on this for a long, maybe four longs time at this point. And so just a veteran of the crypto space who has done pretty much everything under the sun. Welcome, everybody. And with that long-winded and uninterrupted drone, we're going to go to Tim Clancy to talk about the technology of Tornado Cash and why it's needed, I guess, why it was created.
Yeah, so
and then we'll chat.
Sure. If anyone who's made it this far and doesn't know what Tornado Cash does yet, here's the synopsis. Ethereum, wonderful, unstoppable global computer. but it is transparent at the base layer, so you can see very clearly if I send, $100 of Ether to David, people can see that I sent that money from point A to point B. It's pseudonymous. They don't know that, I am address A and your address B, but that trace still exists. What Roman and his team built with Tornado Cash is just a great privacy tool. You can put Ether in, everyone can put Ether in, and then provided that there's a large enough anonymity set, you can have some assurance that when you remove your Ether out, that trace is broken and you can maintain privacy thereon.
And what are kind of some examples of reasons that people would want or need to have this service? And I mean, we've seen some at trial, so maybe there are some specific cases.
Yeah, I mean, at trial, it came up, right? People donating to political causes and they don't want retribution, right? So donating to Ukraine came up. Also, like I learned from your tweet recently that the Ethereum beacon chain deposit contract was deployed by someone funded from Tornado Cash. So just in normal developer operations, that was really how I had been using it before it got sanctioned, right? Like you don't want people stalking your protocol and trying to get early alpha on what might be deploying by looking at known addresses. And a lot of people will use a centralized exchange for that, but we've seen those get blown up and no one wants to have to keep their money there. So Tornado Cash is a good option for just normal developer operations like that.
Can you talk us through that specific case a little bit, Tim? Like the beacon chain. I mean, correct me if this is wrong, but the like dumb guy version of what we're talking about is just these were the contracts that allowed for the transition between proof of work ETH and staked ETH, the sort of new system. But why were those contracts in particular important to sort of keep anonymous, basically?
I would say they're not really super critical to keep them anonymous. It was more just it's like you said, it's a critical piece of infrastructure for Ethereum to have this contract exist and work, and everyone went over it with a fine-tooth comb. It was audited, it was verified to be correct as much as possible. But I think just to have Ethereum be this credibly neutral base layer, they wanted it to be anonymous who deployed it. You don't want to have anyone come and get clout later and like, I'm the guy who deployed this, right? You don't want to see like the Ethereum Foundation deployed it or like one of the client teams deployed it, right? There was a lot of particularly go back in time, look at the context, like the SEC is investigating Ethereum at this time. Is the security, is it not? You don't want to have any perception of there being one guy controlling such a piece of critical infrastructure. And we can get into the control aspect because just like Tornado Cash, there is no control over that contract. It doesn't matter at all if I deployed it, if you deployed it, it's still going to function the way it did, but no one wanted a name attached to it.
Yeah, actually, you've hit on another critical issue for the context of the trial. And can you just talk about that aspect a little bit? Maybe, I assume most of our listeners are going to be people who are familiar with the concept of, blockchains and smart contracts. But, at a high level, can you talk about immutability? Like, what is for example, one of the critical issues here is at a certain point, they effectively burned their private keys of the, I think, multi-sig that maybe, I can't remember whether they controlled the pools or controlled the contracts, but they relinquished control. So can you just talk about that concept of like no longer having control of a contract or other structure you've deployed to the blockchain?
Yeah, I mean, it's super important. It's kind of like the entire reason why we're here, right? If you are able to trust someone to do ongoing operations, a blockchain is not a suitable construct for you. But we can have these contracts. We can have, they're basically just code that lives on Ethereum that runs forever in its way that it's predetermined. And, you see it across DeFi, for instance, like Uniswap is immutable when it does its deployments. The entire office could go bust. Hayden could get hit by a bus. I hope he doesn't, but the whole operation can stop and Uniswap will keep working and continue being a useful product for people to use for what they do. Tornado Cash did the same thing, right? They made it so that, like, even today, it's perfectly legal for American citizens after becoming unsanctioned to go and use Tornado Cash. I used it recently. The entire team is under federal investigation in that trial and it still works, right? And this is like one of the beautiful things of having an immutable, unstoppable contract. And it's, like you said, it's very important in this case because some of the stuff that the government is alleging the Romans and Alexei could have done, they couldn't do, right? They had no control over the core functionality of Tornado Cash. And
And I do want to get deeper into that because another key question is this whole issue of front end relayer pools. I do want to get into that, but let's transition just so we can kind of do a first pass at a high level. Amanda, can you talk to us a little bit about the how would I put this? I mean, maybe just run us through the charges. And then we can talk about some of the complexities. And I particularly want to get to something that I, frankly, after watching this for 3 weeks, still don't totally understand: the issue of the money transmitting business charge and the subclause having to do with illegal money transmission versus licensing. So start at the top, but I want to get to the MTB part for sure.
Sure. Yeah, happy to. So the indictment was filed against Roman Storm and Roman Semenov with 3 charges in it. They're all conspiracy charges, meaning the government has to show that the accused agreed with at least one other person to do the thing that is in each of these charges. So the first charge is a conspiracy to launder money. The second is a conspiracy to violate the money transmission law, Section 1960. And then the third is a conspiracy to violate sanctions. And happy to talk in detail about all of those. But what we've been really focused on, obviously, is the Section 1960 charge, because we think it is so inappropriate for a non-custodial software developer to even be having to talk about whether they engaged in money transmitting. But just to broad overview, like the main theory of liability here is that these developers, according to the government, worked with other people to transfer criminal proceeds. And that is like what underlies each of the 3 charges. The problem is that the DOJ has never distinguished between or has distinguished the concepts that you just talked about with Tim, right? The idea that the protocol is immutable, the idea that the developers didn't actually have control in order to do anything at the point at which the government would have liked them to do something. So all of that is wrapped up in these 3 charges. To zero in on the 1960 charge, that section of the criminal code is meant to be an enforcement mechanism for the Bank Secrecy Act, which describes what financial institutions are. And that defines money transmitting businesses that are businesses that accept and transmit funds on behalf of the public. So Section 1960 was originally written to just be an enforcement of the state licensing laws and an enforcement of the federal licensing laws. But then the Patriot Act amended it and broadened it and added this additional provision, 1960 B1C, which I assume we're going to get to because of the Blanche Memo and all that stuff. But that provision was added with the Patriot Act and said that you could be running an unlicensed money transmitting business if you transfer funds that are otherwise known to be associated with criminal activity. So it broadened it and made it look like it could be similar to a money laundering charge. But there's a whole separate part of the criminal provision, a criminal code for money laundering, which was at issue in this case as well. So 1960 B1B, federal licensing regime. There's FinCEN guidance back from 2019 explaining what FinCEN, the primary regulator of money services businesses, define those businesses to be doing. And 1960 itself says that you're not transferring funds, you're not a money transmitter, unless you transfer funds on behalf of the public. Now, I think it's pretty clear that I can't transfer your funds if I don't have them in my possession, right? I can't transfer anything on your behalf if I don't have it within my control so that I can transfer it. It says it right there in the statute.
And if I can jump in just to kind of like add some color and whatever here, like there is... the way that Tornado Cash works is you get this like secret code. So you send money from one wallet, you have the secret code, you, broadly speaking, create a new wallet that has no connection to any other address on the blockchain, take the secret code from that new wallet, retrieve your money back. So, and I think that this has not been said out loud, but I think this is sort of the underlying logic of what the government is claiming, is that you are moving money from one wallet that you can control to another wallet that you control. But that's, I mean, this is interesting because I don't know if the statute actually uses the words transmit or move and in what balance, but like, you know, there's like some kind of movement happening there, or like some redesignation. You're at a different address on the blockchain, but very specifically, there is no transfer. There is no transfer of control from a different person. to another, right? So I don't know if that adds any nuance there, but it's just like something that's been on my mind is like that question of movement and transmission and what that means seems kind of key here.
Yeah, and the statute does say that. So 18 USC 1960 B2 defines a money transmitter as money transmission as transferring funds on behalf of the public. That's what it says in the statute. So to your point, it does imply that you're moving funds on someone's behalf, right? And when FinCEN interpreted that language, and in the BSA portion of the code, which is a separate part of the United States Code, it says transferring means accepting and transmitting funds. So it's even clearer in the BSA. But what happened in this case is the DOJ took a different position, and I think a limitless position, which is that I transfer your funds in the same way that in their briefing they say a frying pan transfers heat from the stove to your food, right? But they would have you believe that, like, if I make a tool like a hammer, if I make a tool like a hammer and you go take that hammer and you hurt somebody with it, I'm responsible for your use of the hammer that I made, right? And that's just not what 1960 was ever meant to do. So if you want to get into the Blanche Memo, I can talk about how the
No, I actually do. You already got through FinCEN, and the sanctions element is fascinating too, because now they're being charged with violating sanctions, even though Tornado Cash itself is no longer on the sanctions list. Actually, can you just do a little bit on that, and then we'll get to the Blanche Memo?
Yeah,
because it's like there's all of this change that has happened in the course of this trial, this case coming to trial, that has like shifted the ground underneath the charges, essentially.
Totally. And the sanctions charge itself is a novel charge. I wrote about it in the amicus brief that DEF put in support of the motion to dismiss the indictment, but it's a conspiracy to violate sanctions. So what it says is the government has to prove that Roman conspired with, at least agreed with one other person to violate IEEPA, which is the main sanctions law, and its implementing regulations. So in this case, they're obviously talking about North Korea and the Lazarus Group because, according to the DOJ, right, the Lazarus Group, that the Ronin hack happened and those funds moved through the protocol. So according to the DOJ, that means the developers of Tornado Cash somehow agreed to assist North Korea in laundering its money. The problem with that is there is no evidence, and I really mean this sitting here today, we have seen no evidence that the developers of Tornado Cash ever spoke to North Korea, ever spoke or tried to assist or had any contact whatsoever, had North Korea in mind when they made the protocol, right? Like, obviously that's not the allegation. The DOJ is not saying at the time they wrote the protocol, they wrote it for North Korea. So there's just no direct link whatsoever between these developers and North Korea. And we reviewed literally every case, a federal case dealing with an IEEPA charge. And in zero of them is there this kind of theory. In every single case, there's a direct link.
I know you have a hard out, and I have to make a difficult decision here. Before the Blanche Memo, I actually want to talk about this intent question, because I think it's really key. And it was very much the focus of the closing arguments that were made on Wednesday, which is the conspiracy charge. On first glance, you're like, they never talked to the North Koreans. How could it be a conspiracy charge? The conspiracy charge is just that they talked to each other. But the key thing is they had a plan from the very beginning to enable criminal money laundering, and even more speciously to enable sanctions violations. And so this has been a lot of the evidence presented is like these, by the prosecution at least, is trying to make the case that there was criminal intent in the creation of Tornado Cash. So Amanda, before you have to go, can you just talk really, with whatever time you have left, about that question of intent and how key it is to the criminal charges here? And especially on the timeline aspect, right? They built this thing and then 3 years later something happened. So how does that align with this idea of criminal prosecution?
Yeah, so I think mens rea is like one of the most confusing parts of all of this, especially when we're talking about a conspiracy charge versus like the underlying charge itself, because money laundering, for example, has a required mental state, mens rea, associated with it, and it's that you have to knowingly facilitate the transfer of funds.
Yes.
But as you said, the DOJ's theory here is that at the time the protocol was created, that the developers had in mind facilitating or assisting other people to launder money or violate sanctions. And you're right that they could meet that burden by saying they agreed with each other. Like they could say the Romans agreed with each other in order to do this thing. But they have to have agreed to do that thing, right? They have to have agreed to launder money or agreed to violate sanctions. There's
specifically. Not just let's create something and in theory that's possible.
Who knows? Yeah, exactly. And they kind of equivocate on that point, right? Because it's I think been made clear that like no particular end user was in mind when they created the protocol. So the government is, I think, as you saw in closing arguments, trying to mush it all together and say, well, they knew it was possible, right? They knew it was possible that people could use this to do bad things. So therefore they had the required mental state. But that's just not what the law says. Like the case law around conspiracy requires you to hold you responsible for what is foreseeable. So if we're in a conspiracy to sell drugs, but you go off and kill someone, that's not reasonably foreseeable to me. I should not be responsible because you went off and killed someone. So there is that distinction in criminal law that it has to be foreseeable when you agree what you're agreeing to.
Obviously, there is, the reason that this case is important. These criminal questions are very interesting, and they definitely have to do with the way that the law will treat these kinds of tools going forward. But really, the even bigger, like the bigger picture is even bigger than that, I guess, is basically. And I want Molly White to talk now about these questions of, what is the implication for free and open source software? And I also, maybe you can give this a little bit more context and credibility for people who might not be familiar with your work by talking about kind of, I think this is, for some people, going to be a little bit unexpected to see you aligned with pretty much everybody else on this call. So maybe give some background on that and kind of where you stand relative to both aspects of this, the software and the blockchain aspects.
Sure. Yeah. So
not to make it about you, but I think it's an important kind of split perspective that gives some insight.
Yeah, no, I think it's worth at least addressing. Yeah, so I think a lot of people, see me as a critic of, much of the cryptocurrency space. I write a lot about the fraud in the crypto sector, the ways in which I think that, crypto companies are exploiting end users and things like that. And so I think a lot of people have sort of taken that to mean that I am sort of an opponent of anyone who has any involvement in crypto, crypto traders or crypto developers or whatever it may be, which is really not the case. I have no beef with anyone who holds crypto, trades crypto, builds crypto protocols, things like that.
I will say I am opposed to the crypto traders. You people are a lower form of life, but
I
that's
mean,
a different discussion.
You're degenerates, but like I support your right to do that. No, so and I think that when it comes to the Tornado Cash case, we're looking at something that's very different than, say, like the Sam Bankman-Fried trial, right? People look at them and they're like, oh, it's a big, high-profile crypto case. What's the difference? Why does, Molly think that Sam Bankman-Fried should have gone to jail and doesn't necessarily think that Roman Storm should go to jail, right? The difference there is very significant in that, there are a lot of crypto cases, the FTX case and many others, where we're talking about people who are running cryptocurrency businesses who are themselves committing various crimes, fraud or theft or, whatever it might be. And then we have the Tornado Cash case, which is about a group of software developers who, wrote code, deployed that code on the blockchain, and then other people, not Roman Storm, not any of the charged entities, used that protocol to transfer illicit funds, launder money, evade sanctions, whatever it may be. And there's no real question around whether those people did that thing. That's fairly well settled. The question is whether Roman Storm and the other developers had any culpability for that, or the government is trying to make this argument that they should have done more to stop that type of behavior. They should have intervened somehow if they became aware that criminal funds were being transmitted. And we're really running up against this idea of whether or not writing code is itself potentially a criminal act. And this is something that is, this is hardly the first time that question has been raised. I often draw parallels to the 90s when we were having the crypto wars, which was the cryptography wars, not the cryptocurrency wars, the other crypto.
And if I can interject, Tim, I think is actually grabbing it right now, but he brought to the first or second day of trial the PGP code.
Oh, nice.
Maybe Molly and Tim, you two can talk a little bit about the PGP thing you're getting into, Molly.
Yeah, I mean, the long and short of it is that, it used to be that strong encryption, the type of encryption that we're used to using every day now used to be essentially illegal. Essentially if you wrote an encryption algorithm that was too strong for the NSA to decrypt, that was against the law. And there were a number of criminal cases in the 90s that challenged that, basically saying that writing an encryption algorithm should not be considered a crime, even if someone were to use that encryption algorithm later on to encrypt some sort of horrific material or to perform some other crime. Writing the encryption algorithm itself is protected speech, essentially. And that's what we're seeing here in a very similar sense, is that Roman Storm wrote software that can be used for very good, noble reasons that Tim already laid out, protecting your privacy as a, innocent person who's done nothing wrong, but wants to make sure that, your transactions are not being traced. It can also be used, by the Lazarus Group to launder money that they've stolen, or, it can be used to evade sanctions, which certainly the US government doesn't want to see. And so you have a tool that is now being essentially criminalized, or at least the argument is that it is criminal that they wrote that tool. And the government has been sort of trying to dance around this a little bit. We've seen the arguments coming out of the prosecutors that no, we're not saying that, writing the code was the issue. That's why we see so much conversation about, the front end and the various relayers and, other portions of the Tornado Cash service, where they're trying to argue that, they're trying not to go back to that code is speech question. They're trying to make the argument that they were actually running a business, they were running this money services business, or at least they used to be trying to argue that. And that operation was the sort of criminal activity. And, it's sort of similar to like how you can write a virus, but you can't go deploy that virus on the local hospital.
Yeah.
They're saying you can write Tornado Cash, but as soon as you deploy it, you have this active role. But it's, it's a very tenuous argument, I think, in that it doesn't really hold that parallel.
And if I can just do a little bit of detail on that one, the government has really focused on, and maybe Tim or maybe Molly, you can help me disambiguate these, but this is actually something that has been, I think, a little bit less than clearly spelled out for the jury, because Tornado Cash had a web front end, and I'm not sure whether that is different from the user interface that they've referred to in general, for example, that was ultimately deployed to IPFS. But the broad, there's kind of two parts to the government argument. One is that payments were made by PepperSec, the firm that Alexei and the Romans were officially founders of. Payments were made to hosts for the front end, for the user interface for Tornado Cash. And so that's the argument that, no, you're taking an active role. And the government has in various ways tried to argue that the front end control constituted enough for them to have intervened. Again, the time frame here is hard to even talk about, but it's basically once you saw these criminal transactions coming in, you should have changed things so that they didn't keep coming in, basically. And you also should have designed it in a different way in the first place with a central user registry. A very funny part of all of this that we can maybe get to. But The second part, and this is where Tim and Molly, maybe you are good to comment on, is this question of a relayer, because the front end had its own software, but then it also had a relayer attached to it that, to my vague understanding, frankly, directed transactions to specific instances, I guess, of Tornado Cash, of the pools or the contracts. And also the difference between the pools and the contracts, I'm a little shaky on, because there's a lot of talk about how the pools are fixed, but the contracts can be changed using the relayer. I'm probably getting all of this wrong, so I'm just opening it up to anybody who wants to try and explain that a little bit more concisely.
I'm happy to just jump in on the technical aspects a little bit. So the pools were totally immutable, and that's where the actual money is. So, there was, and just before
so it's literally just, here's the Tornado Cash contracts, and they are attached to specific pools.
Yeah. So that was, the government did all their effort to say like the 1 ETH, 10 ETH, 100 ETH pool. And we did see that one testimony about like, well, they could have built it with this centralized user registry. And that was, like you said, it's like, well, yeah, you're charging them for a crime for something that like they could have done, like coulda, shoulda, woulda, right? This wasn't even illegal.
As a software engineer, I love it when the government does code review for me in criminal cases. Like, it's such a weird, like, oh, they should have written this differently.
Yeah, 6 years ago when you were winning ETH Boston, why didn't you think of making it full of narcware, right? I mean, so the pools are totally immutable. So that in that very literal sense, like no matter what the Tornado Cash DAO with the Torn token or the Romans did, never could have touched the money. And that's exactly what you said with the secret note coming in and out. There were contracts on top of the pools that were more just for convenience. They were routers. And then there was the relayer system, and that's a little different. And so the routers, like, yeah, that's what was relinquished over to the DAO, and they had the token for that. And that's why if you go to use Tornado Cash today, you can't use the official interface because the DAO was governance attacked while all the founders were in jail, and now it all points to malware, and it will steal your money if you go use it. So you have to go.
Interesting. Okay, news to be used here.
Yeah. So just to the point of the front end, even they operated a front end, but if you go use Tornado Cash today, you have to go and use a self-hosted like IPFS pinned front end, and there were multiple front ends. So they ran one, but you can go and access it from like any version that's ever been pinned to IPFS with various, display and feature and convenience functions, but you also don't need a front end, right? It's the chain. You can run the Circom circuits yourself. You can do the whole thing in the CLI. You can, and so I think to the trial, like I don't know if they ever even established that like Lazarus did use the front end or use their front end. I would be surprised if Lazarus.
Yeah, I mean this might be something that Taylor
I can comment on this because I know these things. Ready? Lazarus does use front ends. They also use CLIs. They also use scripts that are completely automated. Lazarus is one of the most interesting threat actors in the space because they do actually have a little army of actual humans using a variety of products. In the cases of the Lazarus hacks that went to Tornado that were covered in the trial, like Ronin, they used a variety, and you actually see the different say like the different patterns. You can see, like, we call it like the footprint, right? It's like, what does this group of activity look like on chain? And we have like tools to visualize this, so you can kind of like, you get a sense of it. You can see it change over time, and you can also see like different little trails because there's actually different humans and devices that are actually doing this laundry. I take major issue with the prosecution's assertions about anything because it's clear that they're just not familiar with this stuff, and they're just sort of making stuff up. The reality is that, like, I haven't seen any evidence, and I don't personally know exactly what they were using in terms of, like, was this transaction sent with this UI? I don't know. Was this sent with this? I don't know. I can tell you some of the transactions, especially when they get very regular, that looks like a script to me. They probably wrote their own script. That's very common for them to do. So yeah, anytime we go into like these transactions or this threat actor was doing this one thing, like, I don't know,
I wanted to speak to a couple of different things there that I still had questions about. The first one is to the question of front end, right? I think it was this witness Werlau from Anchain.ai who tried to use gas fees as a proxy for which kind of interface was used. And we got a rebuttal of this in closings and by a couple of final witnesses. But I think that, first of all, let's talk about that. Like, what were the gas fees fixed in the UI that then changed over time? Was that the kind of basic idea, or just like what is the rubric there?
The problem is that all of this is open source, right? Every single bit of the whole thing is fully open source, and it's not just technically open source. Like the ethos of all these builders is open source, and so you have to keep in mind that like when whoever did the first iteration of the UI, right? They made some choices in terms of like what these certain transaction parameters were, how they were going to organize it. They used underlying libraries. There's all these different things that come together, right? From that point forward, every other person who wants to either like create a script or create a new UI or do anything, they're going to look at those the same underlying libraries, but then also the original or like the, you know, the ones that are widely available. And like for us, like for me as a builder, I've been building wallets for a long time. We're all very aware of the fees that the other wallets sort of have as like a default, because if you aren't, so if you're like too high, then all your users are basically like overpaying, right? And if you're too low, then your users, like their transactions take a lot longer to mine and stuff like that. So when we say something like, we're looking at this repo and we're seeing these code changes from date to date to date, that's what they're saying. They're saying, we know that they use this UI because it was this parameter was in this code base, and then it changed over here. The problem with that is, you don't actually have like a collection of all the possible things that they use. Like that's never been, you don't know. You can't know.
You don't know the set.
Because it's all local software at the end of the day. And so it's possible, right? You can't rule it out, right? It could be that, but to say definitively that any transaction is sent with any piece of code, especially with how many layers there are, right? Because also remember, like you have the wallets come into play as well, right? Which have a whole different stack of things that they do. You have the RPC nodes, you have the client software, you have all these different things. So what they were saying was, because the code base for the UI had this one parameter that was hard coded at a certain value, and because we saw these transactions on chain with this hard coded value, therefore all of the transactions with this parameter were sent with this code base. And I'm not saying that none of them were. Some of them probably were, right? But to say that all of them were, okay, so you're telling me that you've gone through every single public and private GitHub repo, also like every single local code base on anyone's machine, and you've verified that there's no other code base that has the same hard-coded parameter? Like, no, you haven't, because if you had, you would have seen all the clones and the iterations and the forks of all the code bases over time.
So what you're saying is that people are copying the code for this front end and just not changing the hard-coded fee value, and that just completely undermines the premise of this kind of analysis. I do want to, before we go, Taylor, into a little bit more detail on the broader tracing issues, I do want to just revisit the idea of these relayers. Because the government is very heavily focused on the fact that this sort of like chain of reasoning where they control the front end, all of the bulk of the transactions are going through the front end. They could have changed the relayer attached to the front end, and then it's kind of like the underpants gnome meme, something happens and then profit. And so my question is, like, that ability to change the relayer attached to the front end, like what can you actually change that's happening between the relayer and the pools if you have that control over a relayer? Like, what does that mean? Tim, you made a sound.
Can I jump in? Okay, so like anyone can run a relayer. That's the other problem. Like, it's straight out, if you buy a DApp node today off of dappnode.com, one of the most popular Ethereum home staking devices, and you plug it in. It has a thing called the DApp store, and the first DApp in there that you can install is a Tornado Cash relayer. It's 2 clicks as a consumer to run this potentially illegal piece of software, but basically what you're doing there is, and you're the one accruing some sort of fee to basically start the bootstrapping problem. And you alluded to that earlier, which is like, hey, I have money in wallet A, I want to get to wallet B has no ETH. Who is going to, execute my secret note and send me the ETH so that I can start this
I'm
process?
sorry. I don't mean to interrupt you, but I think we might be talking about different things because these words are kind of being used a little bit interchangeably at the trial too, because there are the relayers, and these are, in this instance, and I was misspeaking before. There are the relayers who do those like seed deposits and help you withdraw anonymously. But I'm talking about the router, or maybe that's the word.
Okay.
It's
the
attached
router
to the front end and then does what?
It's just a convenience contract, right? Like Uniswap has one. Most DeFi protocols have one. It's a way that you can, go from the front end to get to the pools in a way that isn't like quite as onerous as running the script yourself and going directly to the pools. And that was the one that they gave control over to their DAO, mostly because it can connect to the front end, and the DAO also controlled the ENS name, I believe, for the front end. But like, I don't know. They did talk about that, but that's about as flimsy as implementing things on the front end, right?
Could you use the relayer to like embed an OFAC sanctioned addresses list? I don't even know what I'm talking about.
You could if you changed it, but then people can just get around that and go directly to the pools, right? It's like it's equally as flimsy as doing anything on the front end, which is why it's really funny that the prosecution is like, you put in these really half-assed protections on the front end, like, and you knew they weren't enough, but you should have changed this other thing that degenerates the same like failure case that we just go around it and get to the pools, right? So it's they couldn't have done shit with the router, right? It's like the router's completely ruined right now, and you can still use Tornado Cash, right? And so it's just demonstrably not something that mattered.
And we can get to the relayers a little bit.
I jumped into the relayer.
No, that's okay. I think that like the relayers are like such a, I don't know. It's like there's parts of this that are like so arcane and like edge casey, it's almost not worth talking about.
Right. But, they're only funny to mention because Chainalysis was running one, right? And so it's
right, exactly. Which was a whole other subplot that basically got dropped because of just like witnesses being removed. But Taylor, speaking of witnesses, do you want to go back and I don't know if you want me to do like a little background or if you want to talk about Hanfeng Lin, the prosecution's first witness, and then we can kind of go into some of the I think that like this is important because obviously we don't have a verdict yet, but and maybe Amanda, you can also weigh in on this because this specific thing feels like a very clear grounds for appeal if there is a criminal conviction here. But Taylor, do you want to just kind of do some review?
Yeah, I'll give background. So basically, the very first witness for the state, so the first person on the stand that the jury heard from was super sympathetic witness. I want to emphasize, like I've done a lot of these cases, they just get racked. The pig butchering scams are one of the worst scams. They're long. They take full advantage of the victim. They get them completely like just in a fully trusted state, and then they just take all their money like on repeat, and it's horrible. So she's telling her story. It's like we cannot say that this is not a bad thing, that it didn't happen. Like this definitely happened. She definitely had a terrible thing happen to her. Crypto was definitely involved. Like there was like money. They basically had her set up a centralized exchange account and then wire money to it and then send that money on chain. So
yeah, the
issue is that we were kind of waiting for the shoe to drop in terms of like, where does Tornado Cash come into this? And I think everyone had a sense that this was like a bit of a weird situation for this trial. For me and other people who have traced this type of activity and understand the sort of the specific nature of pig butchering and the laundry networks involved, we were very surprised. We were very, very surprised because they really don't use Tornado Cash. They have their own laundry networks. They have their own mechanisms by which they go between fiat and crypto. They are typically across Southeast Asia. They're not, I don't know, they're not crypto Twitter people, I guess. Like, it's a completely different demographic. And so that was really surprising. We were able to get a bit more, because obviously in the trial, why would anyone put like the addresses of the transaction hashes of these things out there? But I was able to actually find her specific addresses just using the details that were basically in her testimony, like the exact amounts that they went through. I was able to find them, and then I traced out what I thought was a fantastic amount of hops. I call it the crackhead explosion tracing, which is not actually tracing whatsoever. It's sarcastic. You just explode out in every direction to sort of see what's around, get a feel for it, that kind of stuff. In this case, I was obviously looking for Tornado Cash. I was also looking for like anything, or sort of like closing my eyes, so to speak, and being like, I'm not going to actually trace this, but let's see if we can get from point A to point B.
Right, and just to jump in really quickly, I think that this is significant in terms of the method of tracing because, I mean, what you're describing is essentially, like, with some nuance that I'm sure you'll get to, very close to what the actual government expert witness who claims to be making this connection was doing, which is if there's any link whatsoever between these two addresses or wallets, then that means that money was put there to be laundered. As opposed
and
to
presumably,
actual
I
tracking.
think the difference between my crackhead explosion tracing, right, where I just explode out, the difference between that and something that I would do during a normal real investigation, or presumably what the IRS or other investigators are doing during an investigation, is you're starting with the victim's address and you're looking to see, you genuinely want to know, where did this money go? Like, are there indicators that can tell us who's responsible for this crime? Are there other victims that we can get more information from or help as well? Like, these are all the questions that you're trying to answer. You're never trying to say that it went to Tornado, right? You don't know. Like, that's the purpose of the investigation. For me, because I knew that they were saying that it was going to Tornado, the purpose of my quote unquote investigation or tracing was like, find it. I literally wasn't able to find it. Once we had a bit more information, then I was able to find it, but it required me to trace through in the very middle. It required me to trace through an address that to me is very clearly like an OTC desk or a broker somewhere in China, or Chinese speaking at least. And I wasn't willing to trace through that. I would never trace through that. It had over 7,000 transactions over like a less than 2-year period. It also had like over $1.5 billion in flows. Like, this is not this is like some dude who's doing business.
So let me put this a little bit differently, actually, and see how this scans with you, because another way of looking at the trace that Stefan George did is like the presumption of all of these hops through wallets. It basically, this method presumes that they're only hopping wallets to obscure their path rather than there being any real transfers in there whatsoever. So like that seems to be the implicit read, right? And you're saying that at least at one point, if you're talking about an OTC desk, that is somebody buying and selling, right? So there's a transfer of ownership happening there at scale that makes it impossible to use that wallet as a credible link between two possessors, I guess.
Yeah, exactly. And there is, like, I think there's some nuance, right? Because if we say that, like, for example, like Laz hopped 10 times and went to a certain location, that's usually a pretty fine statement to make. Specifically, though, because Lazarus is like trying to outrun the detection and the KYT. So basically they'll take a chunk of money, they'll split off in 10 directions, and then they'll hop each of those 10 times. So now you have 100 addresses, but every one of these addresses is fresh, right? It's a brand new address. So it's like 100% of the money is hopping every single time. There's no other activity. There's no unknown activity, etc. That's a very different situation than a victim's $150,000 flowing through addresses that, you know, we're doing literally billions in volume over, you know, a couple of years. You have to ask the question, like, what are these addresses? What's the other source of money? Like, yeah, all of these questions. And I think it just points to as well, like, people think that on-chain tracing is like magic or something. You just like trace the money and it's like this hard, like, no, on-chain tracing is part of the investigation, right? It is one little piece of an actual investigation. It is not the answer to anything. Like, it just isn't. And so that's the, you know, the ultimate issue that I have with the state opening with this victim is like, that victim is super synthetic. They know it, even, and they also know that let's just say, like, the ties to Tornado Cash are tenuous at best. Like, it's not a solid, you know, they have a lot of cases where it actually does go like pretty much directly to Tornado Cash, but not pig butchering victims, right? Why did they choose this victim? You know, I think we know. And then the other thing is just, you know, like, if you just zoom out, right? Like, you are fully convinced that the state, right, is fully convinced that Roman is super guilty of doing this thing. And then they put this witness on and they claim like it's to show that Roman like knew about this stuff, et cetera, et cetera. I just don't. It defies logic. It defies, right? It's a different game. It points to a different game being played, right? And I just don't appreciate that whatsoever, personally.
And specifically to this idea of knowledge, you know, one of the key things in this trial that unfortunately is very hard to keep straight is the timeline and specific dates. And so I do not remember exactly when Katie Lynn supposedly sent this like note to hello@tornadocash.com or whatever the address was. That I get it mixed up.
So it was months after her funds were stolen, and I think that was October 2021 was when she made all these transfers. She didn't email until April 2022, and I'm not sure exactly what happened in the middle. But also the other thing that I don't even know if it came up in court, but the email that she sent was only a single line email that basically said, please read this letter that's attached. And then there was this 12-page PDF attachment. And look, as someone who's been in this ecosystem a long time and has directly answered a massive amount of support tickets, I would never open that PDF in a million years, and none of my people would either. Like, that is
That's a very good
There's
point.
nothing good in that PDF. And like, I don't know, like...
That's a very good point. But we can also talk about what that PDF actually was, which is, I believe, a report generated by a recovery service called payback.com, which she contacted and paid some relatively large amount of money to supposedly trace these thefts after she lost all this money. They sent her and you know, this is the time lag you're talking about between the theft and her contacting Tornado Cash, but they sent her this 12-page document, which, according to them, laid out their claims that her funds were sent to Coinbase, Kraken, FTX, and Tornado Cash, and that she should contact them to get it back, basically. And in the middle of the trial, and this, you know, how this all went down in the back rooms and in sidebars and things like that is still, you know, I haven't caught up on all my documents. I haven't read all the proceedings, but I believe it was either early this week or the middle or late last week that Paul Graywall from Coinbase said, no, we've looked at this too. We've found these transactions, and this money did not come to Coinbase, which, you know, whatever, it's Coinbase, trust them or don't, but you don't necessarily come out and talk about a public trace if you don't have something to back it up with. And so it really seems like, and I'm sorry, I'm burying the lead here, but payback is being at least warned about, if not actively investigated by the FBI. That runs these like recovery scams. That's like, if you've been robbed, let us rob you again and lie to you about where your money went. And so my broad understanding, or maybe I'm inferring a few things here, but it seems that the government just took that payback report at face value when initially choosing to put this woman on the stand. That is, we already have a trace. We're going to take it for what it is. It's accurate. And then, partly just based on people like Taylor and Lola and others doing digging, it became very clear that that was not, valid. And then
which is, by the way, which is wild. Like, it's because also they keep referring it as a tracing report. It has a single address and a single transaction hash. The transaction hash is actually a swap with token lawn. It wasn't even a freaking transaction of like any relevance. The bulk of the 12-page PDF was what they call and I don't work at a centralized exchange, so I wasn't familiar with this, but I've been told by all my friends that are at centralized exchanges what this is. It's called an ADR, which means it's a alternative dispute resolution letter. It's a thing that these scam recovery companies have basically made up, and it's full of legal gobbledygook. Like, it's just like mushed together. And they send them out to basically anywhere. They have very low success rates. Like the centralized exchanges see these all the time, and they just like roll their eyes at them.
And it's worth noting that Tornado Cash, I'm remembering now that they did reply, and Roman basically said, this is a protocol, we can't do anything. But they were the only ones who replied at all.
Yeah, and that's like, I don't know. Some of this the other thing is, like, to me, as someone that helps victims all the time, the most common response is no response. Like, it is, like, no matter who and what. And by the way, that applies to federal law enforcement too, right? Like, we have victims that are emailing and calling, even if they already have a case opened, right? They can't even get a response from feds. Like, it happens. The cases are hard. People are really busy. The specific nature of what's going on and what should be said and like who needs to say what and whatever is difficult, etc. I don't know. To me, I have respect for people who take the time to reply. Even if that's to say, even that's to educate and say, like, how these things work or whatever. I have appreciation for that. Most of the time you get ghosted because I guess because maybe they have lawyers who've told them don't freaking respond. But that sucks. It's a sucky experience.
And I should also clarify that, like, one of the reasons that Roman responding here is relevant is because, again, the sort of real substance, even though it's like, let's link this crime to Tornado Cash. The real intent is to establish awareness, right? That Roman was aware that this sort of criminal proceeds were flowing through this. And on both that note and, Amanda, on the like larger question of whether there's actually relevance here, could you speak to, and again, I am not a lawyer, so I'm just making this stuff up, but in my mind, that does seem like the kind of thing that you would bring to an appeal. Is that intuitively correct? Or is this something where there's like, what does this do to the status of the verdict?
Yeah. So, well, two different questions. So the verdict right now, right, as we sit here, it's with the jury. The jury will continue deliberating. It can go three ways. They can vote to convict, vote to acquit, or not agree, and that would result in a hung jury. But if if things don't go the way that we hope and they vote to convict, then Roman's team can file what's called post-trial motions, a Rule 29 motion, which is basically to ask the judge to set aside the jury verdict and say that there was insufficient evidence presented at trial to sustain the conviction. And if he loses that, then he can appeal to the Second Circuit, which is the circuit court above the district court that's currently hearing his case. And for any criminal appeal, the appeals court is looking at the decisions made by the trial judge on a legal basis and finding if they're plain error or if there's harmless error, meaning like they can live with those errors, or if they are reversible error, if they are significant enough to overturn the conviction. And a lot of what we're talking about, I would imagine, would amount to reversible error, because anytime the judge makes an evidentiary ruling, like sustains an objection or overrules an objection that the appellate court would disagree with, that's reversible error. If there's evidence that was let in that's highly prejudicial, that should have been kept out, that's reversible error. So there's really, this is the reason why trial lawyers object, is because you're preserving your right to appeal on that basis. So every time you heard objection, that was a moment at which there could be an appealable issue.
Actually, it's like a sub issue there, and I want to talk about the verdict here also with Molly in terms of larger consequences. But I don't know, Amanda, if you were tuned into this, but during the prosecution case, there was essentially a continuing objection from the defense to every piece of, I think, visual or documentary evidence. Were you aware of what the nature of that objection was? Because basically after the first couple of times, which I guess I just forgot, they essentially were like renewing their standing objection to all of the prosecution's evidence. Did you have a sense of kind of what the basis of that objection was, or the nature of it?
There were a few different continuing objections, and what that means is basically like, we told you, Judge, what the basis of our objection was early, and we're not going to keep telling you over and over again, so we're just going to say continuing objection to preserve our right to appeal each time. But there were a few. So you might remember in motions in limine, which were filed before trial, there were all these different issues raised about, like, they should not be able to use evidence that happened after the protocol was created. The government made motions saying the defense should not be able to talk about FinCEN guidance, right? Like, there were all these different things trying to limit each side. So every time you heard continuing objection, it was the continuation of those earlier objections. So hard to characterize just one, but there were a number of them.
Gotcha. We still have a decent amount of time, and so I do want to make sure we get everything from Amanda before she has to go. But can we go sort of back into the big picture stuff? Because Molly, I don't know if you quite finished. I apologize. Just we spiral out of control here. You didn't necessarily finish your initial point about PGP and open source. But yeah, before we talk about, we'll sort of preface the discussion of the verdict with this bigger context of, what does this imply for developers? And I think maybe it was Tim who actually put it to me in the way that has stuck in my mind, is like, now you have to ask yourself what you might have already built in the past that could be used for some future crime that you get blamed for. Is that, Molly, like a fair characterization of what we're facing here?
Yeah, I mean, it's kind of a potentially scary state of affairs for software developers if there is, a successful prosecution here, because again, it seems that the prosecutors are going after the code that the Romans were writing rather than any business that they were operating, any active participation in, transmitting funds like you might expect in a money services business. And so, if you sort of extrapolate a finding like that, then, any software engineer has to think anytime that they're running code, how might some criminal come along and use this service for illicit purposes? And then, what if the government decides not to go after that criminal, but to go after me, the developer who is writing code that, probably had some particular, perfectly reasonable use case. Early into this case, there was an amicus brief from, I want to say it was Coin Center, that drew a comparison between Tornado Cash, basically saying, blaming Roman Storm for North Korea's laundering and sanctions evasion is like blaming developers of Linux for the Iranian weapons, control systems, because they run on Linux, but the developers of Linux weren't out there writing weapons control systems, or certainly not intending to, but the tool that they wrote was later used in the furtherance of those goals. You see similar things, again, going back to the encryption end of things, if you are writing code that uses strong encryption and you are releasing that code, especially if you are running a service that uses strong encryption. If you think of, for example, Signal, which is actively operating the software, they write the software, they are also running servers in sort of an active way that you could, sort of compare to the arguments the prosecution is making around Roman Storm's operation of Tornado Cash. Is the government going to go after Signal because someone used the Signal encrypted messaging app to, plan the bank robbery that they were going to, do, or they were going to, transmit illicit materials online? Like, it's a really scary state of affairs, if this potentially, succeeds, because, I think it opens up a lot of liability for basically any software engineer.
And Amanda, to that point, I think that there's a broader issue here, right? And sort of like at a societal level. Molly, you're talking about the sort of anxiety of what if I build something and it does X, Y, Z in somebody else's hands. And, that's, to my mind, it's this idea that you have to only create the most safe technology that is never going to be able to be used for anything bad, which kind of means you can't create anything. And Amanda, I think that one of the underlying issues here is that it's about ideas, right? Ultimately, what you're talking about is this a dangerous idea? Because Tornado Cash, just like PGP, can be written down in a book. And it, the ability to just put that idea out there is sort of in the blast zone. I think there's a couple, I think, Molly, you put it really well, that like the government is trying to avoid the impression that it's going after the code by this focus on relayers and front ends. But I think it's very interesting to think about the idea that they're just kind of trying to toe right up to the edge of the line and do as much damage as possible to the actual act of writing code. So Amanda, on a procedural level, can you speak to why what is fundamentally a First Amendment speech issue is not able to be brought into the actual trial itself, and then what that might imply, again, on this question of, not to say that there's necessarily going to be a guilty verdict, because I think there's a decent chance that there won't, but this is also another route potentially to appeal, I would assume.
Yeah, and the First Amendment issue was raised by Roman Storm's team at the motion to dismiss stage. When they tried to dismiss the indictment, one of the things they said was this indictment in and of itself is accusing Roman of something that would violate his First Amendment rights if it were to be validated by the court. And the judge did not agree with that argument and denied the motion to dismiss on that basis. So they definitely can appeal that. And I would just say, like, Coin Center has written extensively and brilliantly on the First Amendment issue. So I will not presume to be the expert on the First Amendment point of this. But I think that Molly is right, and you are right about the larger implications of this case in general. I would say there's a difference between writing code and deploying code, but either way, there are First Amendment issues at stake here. And the really dangerous principle that is limitless is if I write neutral code, but somebody ends up using it in a way that they of their own volition decided to do a bad thing with, I'm supposed to be responsible for that conduct. Like, that doesn't make any sense. It's also not how the rest of the law works. Like we've already said many examples, right? But like the creators of the iPhone, Apple, don't get charged because people use their iPhones to go order drugs, right? Sell drugs, do whatever it is is criminal activity. And if they end up in the hands of sanctioned entities, Apple's not responsible for that either, saying they're facilitating a sanctions violation. So I think that there's really large implications here. And ultimately, like, this was a charging decision that was made because they wrote privacy preserving software. There are people who write software all the time that is used in ways that they didn't intend, but like they went after these developers because they wrote privacy preserving software.
And let's jump off of that into what is, I think, pretty clearly the subtext of this entire trial, which is the long-term implications of, if by default the government would say, okay, it's just software, it's decentralized, that's okay, you can do that. You again, this is not to say that this was Roman Storm's intent or the intent of the builders. It is simply kind of a structural fact of life. If you're building a decentralized structure that is intended to provide any kind of anonymizing service whatsoever, you simply cannot collect this kind of information and then have it still fulfill that goal. And so you kind of inevitably, just the same way that WhatsApp lets anybody use it to talk about whatever they want, something like Tornado Cash would let anybody use it for whatever end that they want without any intermediary who can exercise that control. And it is, I think, that fundamentally is, as Amanda said, it's a charging decision, right? Like, they decided to go after somebody for building a specific kind of tool that, as we've said, can be used to evade sanctions, can be used to hide the proceeds of crime. There are these social implications that you can understand the United States government wanting to foreclose. So how do we, maybe we can move into these bigger questions, which is, it sort of implies the necessity of an entirely new paradigm for trying to combat some of these underlying crimes that we're talking about. So how do we, if anybody has ideas, balance the necessity that these tools be structured a certain way with the consequence, which I think we've all kind of said to varying degrees, is, we must acknowledge that these, it's not to say that these crimes are enabled by Tornado Cash, but Tornado Cash is certainly being used. And so how do we balance those two concerns in, I guess one would say, the transition towards a financial system that does not rely on intermediaries as agents of censorship?
So, very timely question, right? We are currently talking about market structure legislation in general. Something that we do at DEF is stand up for DeFi even in those conversations and make sure that the tech itself is not regulated as if it is an actor who is capable of doing things that it's not. So I think there's lots of different ways that we can come at this issue. In the criminal context, I think it bears mentioning that the Samurai Wallet developers pled guilty to a conspiracy to violate Section 1960 this week. So while that case is over, it's not great that there is now a criminal conviction out there on this exact money transmission theory that we are talking about. So I think it's incumbent on everybody to make sure that the law cannot be misinterpreted this way by the DOJ. So like one thing that we're trying really hard to do is actually amend 1960 to make it clearer that the person responsible for running an unlicensed money transmission business must have control and custody over customer funds, so that a DeFi developer cannot be caught up in that, right? Or a blockchain developer broadly cannot be caught up in that. So you can try to change the law. There is another law that is already in the market structure bill that the House passed called the Blockchain Regulatory Certainty Act. And that says that non-controlling, non-custodial software developers are not money transmitters under the Bank Secrecy Act. So if market structure legislation passes with that in there, that is some protection against this happening in the future. But, these are various mechanisms for change. And we'll see what happens, right? If there is a hung jury, then there is room to put pressure on the DOJ to not refile the charges, right? If there's a hung jury, the case it's a mistrial, and then the DOJ gets to decide if they're going to try the case again and do this whole thing all over again. And at that point, I think it's incumbent on all of us to loudly advocate for the fact that they should not refile this case, and they should reevaluate their choices. And of course, if there's acquittal, we all can celebrate and try to continue to make sure those legislative efforts prevent this from happening again.
Molly, what's your sense of the sort of broader social sweep here, right? Like the interplay between technology and the law and what happens. We do have this new availability of like encrypted messaging, right? It's already out there. It's a totally new thing. It has had consequences. Not all of them have been great. What are the consequences of? And I think we can, not to say that it's like inevitable, but this stuff does exist in the world now, right? So how do we deal with it? Obviously there's the legal side, but there's also just like, this is here. So what does that mean?
Yeah, I mean, I think it's kind of the sort of fundamental issue with privacy preserving software is that, as soon as you enable people to have strong privacy, you are protecting that strong privacy both for good actors and bad actors. And, that's sort of always been an issue with privacy preserving software. And generally, at least in the encrypted messaging end of things, we've had fairly good success in defending people's right, at least in the US, to use encrypted messaging, despite the fact that it is regularly used for criminal purposes. I, use Signal every single day and have every right to do that for my completely legal activities, even though, a drug dealer might be setting up, drug deals or, all kinds of activities happening. Because
nothing of Instagram. Wild things.
Yeah. Because, generally speaking, there's this feeling that like you should not do away with every person's privacy solely because there are bad actors out there that you might catch if you could spy on everybody's messages. But, that's sort of what we're grappling with here. And, in the financial sector, there's always been sort of a different approach to privacy where, the idea of people being allowed to have complete privacy in their transactions is really something you only get with cash, and even then it can be a little bit tricky. And so a lot of people don't necessarily have the same mindset of like, I should be allowed to send $100 on Venmo without Venmo knowing, without the bank knowing, without the government knowing. Like, people don't sort of have that in their heads in the same way that they might with messages. And so I wonder to some extent if that's what we're going to run into here, especially with the jury, is like some people just sort of have this feeling that like, well, yeah, like there was crime happening and Tornado Cash, in some ways allowed that to happen, not through any necessarily active participation by its developers or operators, but just by existing. And, someone has to pay for it. And it's easier to make Roman Storm pay for it than it is to make North Korea pay. And so, we're going to find him guilty. And we're going to say that every transaction you make digitally needs to have your driver's license associated with it. And, that's where we need to go.
Yeah.
And there,
Which,
I think,
by the way, there are all these other big privacy rulings coming down now internationally, and some new laws being proposed in the US that are challenging even the encrypted messaging that we've been taking for granted. So,
yeah, I mean, the encryption wars are not won. It's you cannot say that, oh yeah, we won it in the 90s and we're good to go. I mean, there are challenges to those every day that, many digital privacy advocates have been fighting very actively for a long time. And just look at some of the other legislation that's happening recently around, the idea that you need to, provide your identification to access a website. There's all of these sort of ideas that like we need to protect children from potentially explicit content. And the only way to do that is by having you provide your government ID whenever you visit a website, and that's, I think, a really scary direction for things to be going in for very similar reasons. Or in some sense,
even more menacing, the Keir Starmer model, which if you needed any other reason to loathe the English, you now have to give your face to an AI model for it to confirm your age in order to use, I believe, even like Twitter DMs. So, they're just really establishing some insane precedents over there across the pond. You got to love it.
Right. And also forgetting about the fact that anytime you collect data, you are putting that data at risk to some extent. Anytime you demand someone scan their license or take a selfie or, whatever it may be, now the company who has demanded that of you has to secure that data, that extremely sensitive data, in a competent way. And I think every single day we see examples of how companies fail to do that in, with varying degrees of ramifications, going anywhere from like, oh, my email address was, exposed again in a data breach, which we're all sort of numb to very, very serious, situations where people's lives are put at risk because of, perfectly normal things that they were doing online that then got caught up in a data breach. And so, I think that, there's a lot more to these types of laws than maybe appears at first value. If, a lot of people have this idea of like, well, if I'm not doing anything wrong, what do I have to hide? Like, I'll just show my ID and I'll move along. But that's really not how it works. There's a lot more that you need to consider when it comes to these type of things.
Amanda, I know you have to go. Do you want to offer any last thoughts on your way out?
Yeah, no, thank you for having me. I would just say, like, as we watch for this verdict, of course, we're hoping that there's a full acquittal here. And if there's not, we will hopefully do as much as we can to support Roman in appealing this conviction and making sure that the law is changed so that this can't happen again. And just to like provide some context, like, of course, we are primarily concerned about Roman. Alexei Pertsev is still on trial. Well, his trial happened, he was convicted, but now there's an appeal happening in the Netherlands, and that's still very much a live issue because in the Netherlands, the appeal is a total redo of the whole trial. So please don't forget to support him as well as this moves on. But thank you for having me, and happy to answer any questions if anybody thinks of them.
We're going to continue, and we'll talk really quickly about Chainalysis and Tom Schmidt. We don't have Amanda anymore, unfortunately. She could have provided some insight here, but basically, I think this is another really bizarre procedural thing, which is I believe it was last Friday in early morning proceedings, because we didn't have the jury last Friday either. The defense has been trying to call, I think it's a total of 3 witnesses. One is Tom Schmidt, an investor from Dragonfly Capital who communicated or who invested in PepperSec and then communicated with the team as they were managing various aspects of Tornado Cash. He was being called to testify and was taking the Fifth Amendment because his communications, for one thing, have been used to his communications with Roman have been used to establish venue for the trial, which implicitly means that the government is treating his communications as acts in furtherance of the conspiracy being charged here, which is fascinating. And so he has chosen, he wants to take the Fifth Amendment. Additionally, we did find out in that hearing last Friday that the government raided Schmidt's home in the course of the investigation here. So they got a warrant and raided one of the investors. And so he now, quite understandably, is afraid to implicate himself in his testimony towards anything that might be criminal. And on last Friday, the government refused to explicitly say that he is no longer under investigation or at risk of prosecution. They didn't specifically threaten to prosecute him, but they sort of by omission said that, maybe anything is possible, thereby maintaining his grounds for pleading the Fifth Amendment and not testifying in the defense, where presumably the defense would have asked him to, explain why he thought Tornado Cash was something that was worth investing in or worth creating and things like that. And so I guess maybe I'm just doing a recap for the audience, but I thought that was, and then interestingly, we also had the government later say, whoa, no, we actually didn't mean that we were going to prosecute him. That's fine. But then by that time he was already out. So they've done this a couple times of like, we're going to do a little maneuver to kind of edge out a witness that we don't want the defense to be able to call, which has been fascinating. And then Tim, did you want to talk? You sounded like you knew a little bit about the Chainalysis aspect of that as well. There were a couple of Chainalysis witnesses. I think we might have come up short on this one, but
yeah, I mean, I don't really know anything more other than it's very similar to the situation you just outlined with Schmidt, right?
Well,
yeah, I can give a little bit because I actually got really curious. So basically, what seems to have happened is that obviously Chainalysis is sort of come up in the trial and the pre-trial stuff a lot because Chainalysis Reactor is used for investigations. The data is used for investigations. They had what was the other thing? So all the data, I think that they came up as well with the when the FBI was like saying like this much money went into Tornado, et cetera, et cetera. At some point, I guess the defense had asked for some additional records or discovery around certain things that pertain to the state's case. And somehow in that, it came up or something that Chainalysis is running a Tornado Cash relayer. Obviously, the defense is like, wait, what? I think all of us were like, wait, what? Because obviously Chainalysis is a very reputable company, works with the government, like very closely, has always. And that's quite interesting. And so they were trying to dig into that more. For a couple, the defense provided a few different reasons why they wanted to get Chainalysis on the stand that were not specifically regarding the data itself, right? Because this relayer aspect is a big part of the trial. And having a witness who is a relayer would be valid testimony. The issue is that I think Chainalysis seemed to be treating it like there's okay, you're testing my legal limits here, but there's different types of witnesses. Normally, when you have a witness who is going to testify to something, like we saw with the GitHub guy, right? They call it like a custodian of the data. He's just going to come and say like, this is the data that I looked at. And because I know things about the business generally and how we store data, I can speak to the data. And so they exist to bring in the evidence. The evidence is the data though, ultimately. And they are, right? Okay. Then there's a different type of witness who's actually testifying to things, like actual things that they experienced or participated in or observed or whatever the testimony is. So Chainalysis was trying to treat it as a data thing because that's typically what they do with all trials, right? They're just sharing what they know about the data, the blockchain data, the investigation, whatever it is. Because that's not actually what the defense was looking for. They were trying to get someone who actually understood the relayer aspect of it. And that's what the judge ultimately, I think, well, the judge said, yeah, the custodian of the data can come in and testify about the data. That's fine. I don't know why you want that, but that's fine. However, this other witness, if you want this other witness who is part of Chainalysis to come and testify about them operating a relayer, they've stated that they're going to plead the fifth. And then obviously the state also like objected to the relevance of that and all these other things, trying to keep it out. For me, it was most interesting because I didn't know that Chainalysis was running a relayer. I find that fascinating. You know, if the state is going to stand up and say that anyone who like builds, deploys, operates, does anything in this general vicinity, right, is just as guilty as like Lazarus, you have to ask like, what about them, right? And I think that is it's a bit petty, right? Because I don't think any of this is valid, but like I question like the logic and the reason behind this, you know, these sorts of things. And
just to like nail that down, it's like it's sort of almost in two directions at the same time, right? In the on-chain world, what's implied here is that if you provide any sort of infrastructure, and by the way, this also came in testimony in a very interesting way. But if the implication being, if you provide any sort of infrastructure or supporting service to any service on the layer above that then is involved in like a crime, then you're implicated too. And this came up in testimony. I'm forgetting exactly which witness this was, but the defense got somebody on the stand and said, you know, are Ethereum nodes helping run Tornado Cash? And the answer, of course, is yes, they are. And so if you're saying that these relayers are implicated in some crime relevant to Tornado Cash, then so is every other node on the Ethereum network, which is the really crazy part. And then going the other direction, they're saying like on chain you're implicated, and then off chain, if you're a bank, or I'm sorry, if you're an investor and you're investing in somebody, helping them build something that is then later indirectly used in a crime, then maybe you're also liable. So both of these are at play, in not so much as like credible allegations that the government would actually charge, but more in terms of just like, we're going to intimidate and bully you off the stand from testifying in this trial, which I find, you know, it's.
I think it's so interesting though, because I think we presume that the law is going to be sort of upheld in the way that the law is written and the way that everyone expects the law to be upheld, et cetera, et cetera. But to me, I think that the same arguments that they're making against Roman, and this is why it's scary, right? I think they could make those same arguments against both Tom and against even Chainalysis. They're choosing not to. There might be specifics and, you know, little circumstances that make it so that the case is less appealing for them to bring. But the reality is like, you know, the types of arguments that they're making are just such a stretch and such a sort of like a mishmashing of the different like realities that you can't imagine them actually doing that. And I think that that's terrifying, right?
And
like, I think that,
you know, Molly, I want you to chime in, but I also want to just put a little pin in this right here, because that question of like the law as written, I think this is a very easy mistake to make, which is that the law as written gets interpreted every single time that it is implemented through a court proceeding. And so this is where it's also important not to like totally demonize the prosecution or the government, because they are pushing these lines, but it's also kind of like their job as like devil's advocate, or they're there to like play ball basically with the defense and like through this conflict reach some kind of conclusion. And, you know, there's like, it's a very fine line between like, we're going to do the best we can to get this case made, and then we're going to like use weird shenanigans basically to like exclude things. But Molly, we're sort of wrapping up our time here. Do you want to offer something on this, and then maybe we can get to like kind of concluding thoughts?
Yeah, I was just going to say that like the point that you just made around, you know, all of the people they could potentially charge with wrongdoing in this case really came to mind for me during the arguments around the scam victim with, you know, who was sending these emails to all these companies saying, help, you know, I was robbed and the funds went to your company, you know, and they're basically making this argument that Tornado Cash didn't do enough to help her. You know, they didn't, I guess, give her money. I mean, like, you know, it's not even super clear like what they think that Tornado should have or could have even done. But like, they sort of like conveniently leave out that she was sending emails to Coinbase, you know, with she believed that her funds went to Coinbase, and Coinbase didn't respond, didn't give her money back, didn't, you know, do anything. And yet it's sort of Tornado Cash that's being held to the standard of like this customer service that they should have been supplying. The other thing I wanted to quickly touch on, we didn't really get to it, but there's also this sort of issue around the Blanche Memo and one of the charges in this case. You know, originally when this case was filed during the Biden administration, there were charges around operating an unlicensed money transmitting business. And there were sort of two segments of that charge. There was the failure to register portion of it, and then there was the charge around basically in the operation of this unlicensed money transmitting business, you also, you know, were involved in illicit transmission of funds. And you know, after Trump took office and sort of the stance around crypto enforcement change, there was a memo from Deputy Attorney General Todd Blanche saying that, you know, we're sort of going to back off on crypto enforcement. We're going to change the direction of things. And there was this explicit instruction in that memo that prosecutors should not charge 1960 something 1 and 2, or A and B, one of which was the, you know, the first segment of the charge in this case. And so the prosecutors later came along and said, we're not going to continue to pursue that charge, which to me, I think was when things really started to fall apart for the prosecution in this case, because they are stuck in this weird world where they're trying to argue about all of the things that Roman Storm and the other developers at Tornado Cash should have done to comply with the laws around, what you need to do as far as KYC or anti-money laundering if you're going to be running this money transmitting business, while they are also acknowledging that they cannot, or at least will not, charge that he was not, or that he was, failing to register. And so they have this sort of imaginary, set of compliance activities that he should have been doing that he couldn't possibly have known about because they're not written down anywhere. They previously were saying we think you're a money transmitting business, you didn't follow these rules, and so we're going after you for that, which at least has some like coherence to it. But when they dropped that, now they're in this crazy world where it's like, you weren't doing what we sort of have dreamed up, and so we're going to send you to jail for that. And that, I think, is one of the craziest parts of this case, is that they're basically just saying that we want you to do these sort of undefined compliance activities. And I think that it's somewhat similar in a lot of people's minds to some of the previous prosecutions around crypto companies who've basically said, we didn't know how to follow the law, it was not clear to us how we should be regulated. But I think there's one very key distinction in this case, which is that in those cases, the government has always basically said, no, we do think that this was the law that you should follow. And they prosecuted them for that. They prosecuted them for operating an unregistered securities exchange or something like that. In this case, they've dropped even the pretense of saying, we think you are operating as an unregistered money transmitting business. And that is insane to me.
Yeah, it's this like, it's very, well, I don't know the exact metaphor, but they're like splitting the baby in half and only keeping the feet or something. I don't know.
I'm throwing out the bathwater. I don't know where that metaphor goes.
They're splitting the baby in half and keeping it in the bath, or I don't know. But it's like so bizarre. But I will say there was also just one exchange that really struck me about this, is that one of the sort of there's so many sort of fights going on about the language that people can use at every level. I mean, in this particular case, there are a lot of chats where the word compliance is used or some variation on that. And what's interesting is that they have specifically had to instruct the jury that, like, you can't take this discussion of compliance as any indication that there are specific compliance laws that they were trying to comply with. You can take it as an indication that they knew that there were means to block bad actors from using the service. There's just like, and I don't even know what that means as I try and like reconstruct it, but like there's all of this like hair splitting and weird stuff going on on the procedural end that ultimately, like, it's kind of like, I spent a lot of time this past year because I'm working on my FTX book trying to do like the financial tracing within FTX and like where all this stuff went. And at the end of the day, it's kind of a weird parallel to this trial because you just kind of throw up your hands and you go like, it doesn't matter because it's all so tangled and incomprehensible. And like, what is a jury even going to do with this is hard to figure out. And of course, we're going to find out soon. Taylor or Tim, do you want to kind of give your like summary thoughts or anything that we've missed that you think is particularly important?
I mean, I think the most important thing is that whenever we have cases like this, which is somewhat frequent, relatively speaking.
Yeah.
I think a lot of people have sort of these adjacent takeaways that like crypto's all bad, crypto's all money laundering, crypto's all crime. There's victims everywhere and everyone's just money laundering and on and on and on. I think it's really important to remember that, like, number one, there's a lot of legit stuff happening in crypto. There's also like a whole spectrum of not so legit stuff, but like there is a lot of legitimate use and innovation and things happening in this space. The other thing to keep in mind is like the people who are actually scamming, defrauding, hacking, stealing from people, those people should be punished for those acts. 100%. And there should be, not only should they be sort of like legally punished, but like social repercussions, financial repercussions. Disruption campaigns should be a thing that we do to make their lives more difficult. I think that a lot of times with crypto, because it is new, because it is, there's so much innovation happening and things are getting changed around so quickly, they go, wait, why aren't we catching more of the crypto criminals? What the heck? And the answer is Tornado Cash or Samurai Wallet or this other thing, right? Because you can put a name and a face on it. I want to emphasize, you can put a name and a face on every single one of these criminals. Like the blockchain is open. There's a lot of different things you can do. The fact that we're not doing it, I think is a problem. And I would really, really, really like to see U.S. law enforcement, U.S. prosecutors especially, get better at actually trying to stop the crime and actually trying to help victims. I think that would be really worth doing. I think having recourse for victims would be amazing. And I think that continuing with this trend of going after things like Tornado Cash, one, it's nonsensical. It doesn't actually help the situation. It doesn't help the victims. It doesn't give recourse. It doesn't.
Specifically because, as you've pointed out, a lot of these operations just use completely different methods.
Yeah. And there are things that can be done. And it's just that you have to get a bit more collaborative, usually internationally. And so therefore, there's, I guess, easier bad things or things that have a more stable name, like Tornado Cash, right? That get pointed at. I think that that's the tragedy here, right? Is that ultimately, if we zoom out far enough, the government and the people in crypto and the victims all want the same thing, right? Which is fraud, theft, scams to go down and people to be held accountable for their actions. I'm not convinced that the Tornado Cash trial or Samurai or a lot of these other ones actually do that. And if we're not doing that, then, that, in my opinion, that sucks. That just really sucks.
It's a diversion of resources. It's essentially, it's a version of the streetlight problem, right? You're looking for something because there's a particular spot where you can look more easily, at least. Tim, do you want to give your thoughts as we wrap up here?
Yeah, I'll say what I think Niraj from Coin Center put it the best, right? Which is like, I'm going to read his tweet here. I'm sorry that your warrantless surveillance regime was built on the assumption that people would always need intermediaries to transact. And that's really fundamentally what we're doing here, right? It's like, we're going to win in the end. It's just a matter of, is Roman going to be martyred and will it happen before I'm an old man? Like, this genie's out of the bottle. Encryption's not going away. Crypto's not going away. We're getting regulatory clarity. This might all become more civilized eventually if we're going to be even remotely hopeful. But back to your question about, like, how do we balance the needs of what the government needs and what privacy needs? I say, fuck the balance. We don't balance it. We didn't have this warrantless surveillance regime 50 years ago, 60 years ago. And people were still alive and living normally in this country, right? This is all a relatively new construct. And just because we're on the internet now, it doesn't mean that privacy disappears forever. And just because it's money doesn't mean that privacy disappears forever. And so, I think the prosecutors are deeply, deeply evil people. And I hope Roman wins.
I won't co-sign that sentiment specifically, but you are certainly free to hold it. Does anybody else? Molly, do you want a last word, or how?
Yeah, I think I, broadly agree with a lot of what was being said here, is that, we really need to focus on what the world we want to see will look like. And, should that be a world where every financial transaction you make is surveilled? Or should it be a world where you have some ability to transact privately and maintain your own personal privacy and, extend that out to everything you do, to have some privacy online in an increasingly digital world where there are increasing ramifications for not having privacy. And I think we need to be really cautious about where things are moving. And, I think that, speaking to the crypto world specifically, I would be very cautious around some of the legislation that's coming out in the cryptocurrency world, which is being sort of advertised as good for crypto, good for the industry, good for, crypto holders or people who are using crypto, that actually would pare back a lot of the privacy that people are hoping to see. You know, if you look at some of the laws that are being proposed, there's actually some fairly, scary financial surveillance portions of those laws. And so, my recommendation when it comes to the sort of direction that things are going in terms of crypto legislation is that be very careful that the laws that you're supporting or that you're encouraging your legislators to vote for are ones that are actually beneficial to you as a cryptocurrency user or as someone who values privacy online, or whatever you might identify with, rather than the laws that are just sort of being stamped by the crypto industry or the crypto lobby as good for crypto, good for you, because those two things are not always the same. Good for the crypto industry versus good for the individual crypto user are often
Yeah.
actually at odds, I would say. Because, I think there is a very serious threat that, some of these regulations that are being sold as, improving the state of affairs for crypto actually worsen the state of affairs for privacy, financial and otherwise.
Yeah, and it is an extra unfortunate layer on top of all of this is that, like, yeah, the lines of division on this case, or just more generally, are not just like people who get crypto and like understand the legal principles of open software development versus those who don't. It's like there's a bunch of people nominally within crypto now who are pursuing various ends that are actually not good for really anybody except themselves, which is just an added layer of infuriation to all of this. But on that depressing note, the situation right now, just for anybody who's listening and is curious, we are going into the weekend. There was no court today. There was a standing conflict with one juror who isn't able to be there on Fridays. So we've had one day of deliberation. The jury asked for various documents, and it's clearly thinking very hard. We go into Monday at 9:30 a.m. Monday. The jury is going to go back into deliberations. At this point, really anything is possible. The jury is allowed to deliberate in theory for as long as they want. Part of me wants to say we're likely to get a verdict Monday, but it does seem like it's possible we go a couple more days. I'm going to be there sitting, waiting for the note to come out from the back of the room. I don't know anything about the prospects, but stay tuned Monday, I guess, is the thing to say. So thanks to Tim Clancy, Molly White, and Taylor Monahan, and after 3 weeks of this, my brain is melting, so I'm forgetting Amanda Tuminelli, our fourth guest who from the DeFi Education Fund, for being here today. And I'm David Z. Morris with The Rage, and we'll find out either Monday or not on Monday how all of this theoretical discussion turns into a real verdict. So thanks everybody for coming out, and we will hopefully have some form of like after action continuation of this conversation as well.